Welcome to this explainer. Today, we're going to unpack the fascinating and honestly mostly hidden administrative machinery that churns behind our most personal legal milestones. Whether you're single, married, or divorced, this paper trail literally affects all of us. When we think of saying I do or getting a divorce, we naturally focus on the emotional journey, right? But behind the scenes, there is a massive, complex paper trail governed by a whole web of statutes, county rules, and state laws.
All right, let's dive right in with a simple question that might actually make you pause. Can anyone, any random person, hop online or walk into a local courthouse and look up the intimate details of your marriage or divorce? Now, you might assume the answer is a simple yes or no, but it's actually way more complicated than that.
Section 1. Are your records public? The national patchwork of privacy. To answer that opening question, we really have to look at the United States as a whole. And that's because the rules governing vital records change drastically depending on where you're standing. There is absolutely no single federal standard for this.
There's actually a pretty stark divide across the country. In states like Alabama and Minnesota, these documents are entirely public. They're considered non-restricted public records, just totally out there for anyone to see. But on the exact opposite end of the spectrum, states like Alaska and Idaho lock these vital records down for half a century. Literally 50 years have to pass before the general public can even request access to them. Geography truly dictates your privacy here. Take Arkansas, for example. These records are totally exempt from the Freedom of Information Act, so they're mostly restricted to just research and family. California, well, they leave them public unless you specifically go and ask the court for a confidential marriage. But today we're going to zoom in on Idaho as our primary case study. Their strict 50-year confidentiality rule gives us a perfect lens to see how these laws actually operate on the ground and how state and county powers interact with each other. Section 2. Closing the age loophole. Idaho's legislative journey. Now, what's really fascinating here is how a seemingly simple piece of administrative paper is deeply tied to some incredibly complex child protection policies. Historically, Idaho's laws were, well, surprisingly permissive. Prior to 2019, the state actually had no statutory minimum age for marriage at all. If you were under 16, you just needed parental consent, a physical exam, and a magistrate judge's approval. That's it. But over the span of just 2 years, the state rapidly overhauled the whole system. In 2019, they passed a law creating an absolute ban for anyone under age 15. Then, literally just a year later, in 2020, they passed House Bill 466, which pushed that absolute minimum age up to 16. No exceptions, no judicial overrides whatsoever. So the real game changer here is this bright-line mathematical rule introduced in that 2020 legislation. It's called an age parity restriction. Basically, even if a 16 or 17-year-old has written parental consent, the county clerk has to impartially deny the license if the age gap between the minor and their intended spouse is 3 years or more. It's a strict mathematical equation built directly into the administrative process to absolutely ensure young minors cannot marry significantly older adults. But, here is where the messy reality of government administration kicks in. Surprisingly, even though the state mandated these new age minimums years ago, several county recorder websites, like Bingham and Kootenai counties, still suffer from what we call administrative lag. If you go to their websites right now, they still display the old repealed statutes saying minors under 16 can marry with a court order. Now, statutorily, the new state law absolutely overrides this, but it's a super fascinating glimpse into how information flow can just kind of break down between the state capitol and the local county clerk's desk. Section 3. The cost of a license. Following the money. Moving right along, let's examine the actual transaction at the county clerk's counter and the fiscal architecture behind it, because getting married isn't just a legal contract, it's also a financial transaction with the state. When you hand over your hard-earned cash for a marriage license, you might just assume it pays for the paper and the clerk's time, right? Well, you might be surprised to learn exactly what social programs you're actually funding when you say, I do. Check this out. Out of Idaho's $26 baseline marriage license fee, $11 go to the district court fund to cover typical administrative costs. But the remaining $15, which is the majority of your fee, by the way, is legally dedicated to the state's Domestic Violence Crime Prevention Fund. It's a really deliberate piece of statutory architecture. The revenue generated from starting legal unions directly funds shelters and crisis lines for victims of domestic abuse. However, your actual out-of-pocket cost is going to vary across county lines. While the state mandates that $26 base, counties can add their own administrative surcharges. In places like Canyon and Bonner counties, it's $28. But in Ada and Valley counties, it's a $30 total. Why the bump? Because they actually bundle the fee with the prepayment for your first certified copy of the certificate, which then automatically gets mailed to you after the wedding. Section 4, making it legal, signatures and solemnization. Once you actually have the license in hand, the administrative life cycle shifts from the state directly to your chosen officiant. Because remember, just issuing the license doesn't make you married. Solemnizing it does. Idaho law vests this solemnization authority in a very specific list of people. Mayors have statewide authority, which is pretty cool. Religious clergy are authorized. And interestingly enough, they don't even have to register their credentials with the state beforehand. But there is a very quirky caveat for judges. A federal judge can marry you in Idaho, for sure. But if you have a friend who is a state or local judge from outside of Idaho, say from Washington or Utah, they are legally barred from performing your ceremony in Idaho. Make it make sense, right? And here is a highly unusual twist compared to a lot of other states. You've probably seen movies where the best man and maid of honor signed the marriage license, right? Well, in Idaho, that doesn't happen at all. The state completely drops the requirement for any witness signatures. As far as the state is concerned, the authorized officiant is the absolute sole witness of record required to make the whole thing legally binding. Section 5, accessing the paper trail, the life cycle of legal records. To wrap up the legal life cycle, we need to look at what happens when a marriage ends, either through divorce or probate, and exactly how the public accesses that paper trail. Because while those vital certificates are locked up, court proceedings are a whole different story. If you ever find yourself needing to pull civil or criminal court records in a place like Ada County, which handles a massive volume of these cases, you'll find the process is incredibly structured. Idaho maintains a very strong presumption of public access to court records. You can navigate the statewide iCourt system online or file direct requests with the clerk, paying a statutory fee of just $1 per page for copies. But there are strict boundaries. While court dockets are generally open, Idaho Court Administrative Rule 32, or ICARE 32 for short, strictly seals sensitive family court documents. We're talking about things like adoption records, the termination of parental rights, and sensitive evaluations in divorce or custody disputes. All of that is completely restricted from general public access. You'd have to prove a direct, legitimate legal interest to view them. And bringing it all back to where we started, remember that the actual vital certificates, the core proof of marriage and divorce held by the state's Bureau of Vital Records, are guarded tightly by the state for 50 years. So while you might be able to see a divorce case listed on the public iCourt docket, the certified vital record itself remains locked away, accessible only to the parties involved or their immediate legal representatives. I'll leave you with this thought. We've traced this paper trail from the strict map of age parity laws to the funding of domestic violence shelters, all the way to the sealing of family court records. But in an era of unprecedented digital transparency, does locking down these vital records for half a century actually protect our most vulnerable private moments? Or does it just prevent us from fully understanding the institutions and demographic shifts that govern our society? Thank you so much for joining me on this explainer, and I really hope this gives you a completely new perspective the next time you or someone you know signs on the dotted line.